Start. Firstly, dealing with the argument of the learned counsel for the defendant petitioners qua limitation. In the present case, the suit has been filed on the ground that the plaintiff respondent number 1 had become joint owner of the suit property of her father as detailed in the plaint stop. It has been averred in the plaint that on the death of Babu Khan, plaintiff respondent number 1 was entitled to inherit 1 by 9th share of the suit land stop. The mutation was entered into on the basis of the intestate succession, and plaintiff respondent number 1 was excluded from the inheritance stop. It will be a matter of evidence as to whether the suit is barred by limitation, in as much as it is well settled that mutation is not a document of title and no right accrues in favor of any party on the basis thereof. Hence, whether the mere entering of mutation in 1993 would attract the law of limitation cannot be gone into in the proceedings under Order 7, Rule 11 CPC stop. Further, dealing with the second argument of the learned counsel for the defendant petitioners that the ad valorem court fees ought to have been paid since the plaintiff respondent number 1 is not in possession. A meaningful reading of the plaint reveals that plaintiff respondent number 1 has sought joint possession of the suit property stop. Honorable Supreme Court in the case of Suhrid Singh alias Sardul Singh versus Rantir Singh has held as under stop, where the executant of a deed wants it to be annulled, he has to seek cancellation of the deed stop. But if a non-executant seeks an element of a deed, he has to seek declaration that the deed is invalid or non-honest or illegal, or that it is not binding on him stop. If A. the executant of the deed seeks cancellation of the deed, he has to pay ad valorem court fee on the consideration started in the sale deed stop. If B. who is non-executant is in possession and sues for a declaration that the deed is null or void and does not bind him or his share, he has to merely pay a fixed court fee stop. But if B. a non-executant is not in possession and he seeks not only a declaration that the sale deed is invalid but also the consequential relief of possession stop, he has to pay an ad valorem court fee stop. In view of the law laid down in the case of Suhrid Singh, ad valorem court fees would not be payable stop. Being a co-sharer, the plaintiff respondent is seeking a declaration that she is in joint possession stop. Hence, the argument of the learned counsel for the defendant petitioners stands rejected stop. The third argument of the learned counsel for the defendant petitioners that no cause of action has accrued in favor of the plaintiff respondent number 1 also is not a question which can be gone into at this stage, as prima facie the case set up by the plaintiff respondent number 1 is that she has a right to inherit the suit property as her father Babu Khan had died intestate stop. In view of the above, there is no merit in the present revision petition and the same is dismissed accordingly. Stop.